day. My name is Teo Sing Hui, and today I will be discussing on the topic of law revolving the identifications of fittings and fixtures of a property. In the Land Property Act 1925, Section 205, it provides the definition of land, which includes the land of any type, mines and minerals, whether or not they are separate from the surface, buildings, regardless of how they are divided, and other physical properties. It also covers other incorporeal hereditaments. Additionally, it encompasses the rights or benefits related to the lands. There are 3 types of physical extent to the land in general, which are rights to airspace, surface, and subarrian. In the case in question, I will be mainly discussing on the rights over the items on the surface of land. The main problem in the question would be whether the exquisite paintings and sculptures from the Victorian era constitute to fixtures or fittings. The general rule, according to the legal Latin maxim, which means any item affixed to the land becomes the land itself and are known as fixtures. There must be a distinction between fixtures and fittings. Fixtures are items included as part of the conveyance of land and will be owned by the person who has ownership of the land as a whole, whereas fittings are items separated from the land, and thus ownership is dependent of the land's ownership. On sale of the land, the ownership of the fixtures transfers as soon as the contract of sale is binding, and the seller can no longer remove these items from the property. The burden of proof is on anyone contending the existence of a fixture. For example, an item fixed to the land by only its own weight is presumed to be a fitting, and the party that is claiming that it's a fixture will carry the burden of proof. Conversely, if an item is so attached to the land that it forms part of the land itself, it will be considered a fixture, and the party claiming it to be a fitting would carry the burden of proof instead. In the case in hand, both the paintings and sculptures are fixed to the land by its own weight, and it's therefore presumed to be a fitting, and the party claiming otherwise will be Abraham. Therefore, the burden of proof to determine annexation lies on Abraham. Firstly, we will be talking about the paintings that were hung on the wall of the property and could be easily removed. The landmark case of Hallowell and Eastwood, where a claimant, a factory tenant, owed rent to the defendant. In response, the defendant entered the factory and seized several cotton spinning machines to recover the debt. These machines were secured to the floor with screws. The claimant argued that the machines were fixtures and not chattels, and therefore could not be discharged from debt. The test to determine annexation was established. The first thing to consider would be the degree of annexation, and secondly, address the purpose of annexation. Following the case of Holland and Hoxton, the owner of a mill mortgaged the mill to the claimant and later transferred all his property to a trustee who is the defendant under bankruptcy provisions. The trustee seized looms that were attached to the mill by nails or wooden plugs to keep them stable during the use of the property. Although the machines could be easily removed without significant floor damage, the claimant is initially granted an order which the defendant appealed. This case further clarified on the purpose of annexation, focusing on whether it was intended to increase the value of land or for the better enjoyment of the item. In this case, Justice Blackburn stated that an article which is affixed to the land, even slightly, is to be considered as part of the land, unless the circumstances are such too that it was intended all along to continue as a chattel. The onus lying on those who contended it as a chattel. The general rule is that the degree of annexation has priority over the purpose of annexation. Next, the purpose of annexation, where in the case of Lay and Taylor, where Madame de Felp, a life tenant of a stately home, had hung valuable tapestries that were nailed to the canvases attached to the wall. After her death, a summons by the remainder man led to a ruling by Justice Bryan that the tapestries were fixtures and thus part of the freehold. However, the Court of Appeal reversed this decision, declaring the tapestries as chattels belonging to Madame's estate, prompting an appeal by the remainder man's representatives. The court considered closely the degree of annexation, which was the slight as which was as slight as the nature of tapestries would permit, and the intent of the life tenant in hanging the tapestries, which were put up for ornamentation and for the enjoyment of the person while occupying the house. Applying to the case in question, firstly, to consider the degree of annexation, which is the extent to which the item has been attached or annexed to the property, the paintings in question could be easily removed, which means it is very likely that it will be considered a fitting. The annexation of the paintings in question would also seem to be purely for the better enjoyment of the land, which would constitute it to be also a fitting. Subsequently, the question arises whether the sculptures, which were made of marble and were extremely heavy but were strategically placed around the property to enhance its aesthetics, are considered fixtures or fittings. Applying the test stated in the previous slides, the degree of annexations to the sculptures, they were extremely heavy, which can be used as an argument for Abraham in saying that they are fixtures. Next, we look at the purpose of annexation, which is the reason why the property has to be affixed to the land. The first question would be whether the annexation was to intend to increase the value of the land. In the case of the Encourt, a life tenant had furnished his mansion with various heirlooms, leaving them to be enjoyed by the future estate inheritors as per his will. Upon his death, A became the life tenant, and after A's death, B inherited the estate. However, due to a shifting clause in the will, C became entitled to the heirlooms. The question then arose as to which items were chattels passing to C and which were fixtures of the property. It was held that an item may still constitute to a fixture even if it's not physically attached to the property or if the attachment can be easily removed. This applies particularly in this case where the items are an integral part of the property's architectural design. Although Abraham could argue that the sculpture was placed to increase the value of the land because the sculptures were strategically placed around the property to enhance the aesthetics, it is hard to show that the item forms an integral part of the property. Next question was whether the annexation was for the enjoyment of the item annexed. For instance, in the case of Berkeley and Powlett, similar to the case in question, the plaintiff purchased an estate intending to develop it into a tourist attraction. The estate included pictures fixed in recesses of paneling in 2 rooms and a heavy statue of a Greek athlete. After the purchase, the defendant removed these items. The plaintiff sued for compensation for the return of the items. Lord Justice Scarman viewed that the pictures and statues reflected the personal taste of the estate's occupier and were not fixtures that would transfer to the house buyer. Instead, they were personal items that the seller could remove. The items were considered to be merely decoratory in nature. In Abraham's case, it is more likely that the court will consider the sculptures to be fittings because it was strategically placed around the property to increase the overall aesthetics, which is enough to show that they are merely decoratory in nature and are not an integral part of the design of the property, which means that the ownership will not transfer to Abraham. In a journal article, Is Sculpture Land?, Iljatica examines the case of Tower Hamlets and Bromley in her article. The court declared that the statue would not lose its aesthetic power if it was removed from the land. Iljatica remarked on a significant relationship between the object's location and its classification. Specifically, if an object's aesthetics value may be partially derived or dependent on its location, it is more likely a fixture. Conversely, if an object's aesthetic value is independent of its location, it is more likely considered a fitting. In the case in question, it has been stated that the sculptures are placed to increase the aesthetic value of the property and not the other way around, which shows that it would more likely be considered a fitting. Moreover, the value of these paintings and sculptures are high. Brenda's argument that the high value precluded their inclusion is reasonable, given that high-value items are typically sold separately or clearly stated in a contract. And during the finalization of the sale and purchase of the property, none of them brought up the inclusion of the paintings and sculptures. Neither was it stated in the sale and purchase agreement. However, in terms of express reference to contract of sale, there's a case of Hemp and Bygrave, where the claimant made inquiries regarding whether the garden would be included with the sale, and the defendant suggested that they would form part of the property past. The court held that although the questions prior to the contract did not provide a warranty on the part of the defendant that the items would form part of the land. However, the discussions impacted the purpose of annexations and thus had the effect causing the garden ornaments to be considered fixtures. In the case in hand, Abraham asked if the paintings and sculptures would be included in the sale of the property, to which Brenda vaguely replied and said they would discuss on this further if he sealed the deal immediately. Applying the Hemp's case, although the questions prior to the contract did not provide warranty but it is arguable that Brenda saying that they could discuss it further if he sealed the deal affected the purpose of annexation, because it would seem to imply that the sculptures and paintings are to be passed on to Abraham on the purchase of the land. A further case to back Abraham would be the case of Taylor and Hammer, where the claimant purchased a house from the defendant with the sale particulars mentioning several stone garden ornaments. The claimant inquired if these items would be included, and the defendant implied that they would be part of the property. After the sale, the claimant discovered that the ornaments had been removed by the defendant and initiated proceedings for their return. In this case, the court held that the fact that the respondent attempted to conceal the removal of the paving slabs and had given dishonest answers as to pre-contract questions on the matter prevented him from relying on the principle of caveat emptor, which is the principle that the buyer alone is responsible for checking the quality and suitability of goods before the purchase is made. The nature of the agreement relies on what a reasonable person with the same knowledge as the parties in the time of the contract would interpret the discussion to mean. To a certain extent, a reasonable person in Abraham's situation would consider that discussing this further means that the agreement should be found to include the paintings and sculptures. Also, the fact that Brenda tried to conceal the fact that the painting and sculptures are not included in the purchase of the land would prevent her from relying on the principle of caveat emptor as well. So, in conclusion, for the paintings hanging on the wall, after considering the degree and purpose of annexation, it is very likely that they will be considered fittings and the ownership would not transfer to Abraham with the property. As for the sculptures, taking into account the degree of annexation and the purpose of annexation in general, the sculptures are merely decoratory in nature. It will be considered a fitting. Hence, looking at the general test for annexation, both the paintings and the sculptures are to be considered fittings. However, Abraham also has room for argument in terms of express reference to contract. Abraham might be able to claim both the paintings and sculptures due to the fact that Brenda tried to conceal that the painting and sculptures are not included in the purchase. That is all for my presentation. Thank you.